Thank you for joining us today. My name is Jessica Cheshire with the New York State Science and Technology Law Center at Syracuse University College of Law, and I would like to introduce our presenter today, Professor Shubha Ghosh, Director of the Technology Commercialization Law Program at the Syracuse University College of Law, and he will be presenting today on recent and upcoming Supreme Court IP-related cases.
Thank you, Jess.
And thank you for the audience for participating, registering. I guess this is launching the webinar series for fall of this academic year, and we have some great programs lined up that you can find out more about from our webpage and from our listservs and so forth. Today I'm going to pick up with some things that I did last spring on some cases regarding intellectual property at the Supreme Court and let you know how they came out and give you some analysis of those cases, as well as talking about some of the upcoming cases. This is going to be a rich year, people are saying. There are at least already 4 cases, and there are possibly 1 or 2 more that the Supreme Court might grant a review of. And so we'll talk about this. So we've got a total of 3 cases from last term, 4 this term, so that's 7 cases to talk about in the next hour. But they're rich cases, lots of interesting detail, and lots of interesting practice pointers that can come up. So welcome, and I look forward to your questions and any comments you might have either during the presentation. Feel free to text those in or email those in, and look forward even to hearing from some of you after the presentation. So the overview, as I mentioned, is to discuss the 3 cases from last term and then the 4 upcoming cases for the 2016 term. Talk about the relevance for practice. These cases range from patents to copyrights to some trademark law potentially. And so they have a wide range of practical applications that we'll talk about today. And then we'll talk specifically within the broader world of practice to the specific practice area of tech transfer and transactions, which is the focus of our center and tends to be one of the big themes in this webinar series. So the cases that were decided last term, there were 3. 2 of them, some of you may remember there were some webinar presentations that I gave on each of the first 2 last year. And so the first one is Halo versus Pulse. I did a webinar series on that last March. And this had to do with the standard for getting enhanced damages in patent law. The long and short of it is that the Supreme Court has overruled the Federal Circuit and effectively has made it easier to get enhanced damages, or at least changing the standard in a way that may be lowering it. The next case was the heavily watched Quozo Speed Technologies versus Lee. We had a webinar about this in April of this year. That had to do with inter partes review and the standard for deciding whether to grant inter partes review, as well as what the standard is for patent interpretation within that proceeding and by the PTO. Basically, the bottom line is that the Supreme Court affirmed the broadest reasonable interpretation standard and lack of judicial review of USPTO decision on inter partes review. So spend a lot of time talking about this in April. I'll review some of those materials that we talked about in April, but give it a spin based upon how the court actually decided the cases. In some ways, neither of these cases were that surprising in terms of the result, but they're both pretty important cases about the practice before the U.S. Patent and Trademark Office, as well as in front of federal courts. The third case we didn't really talk about that much during the last season of these webinar, but it's an important case regarding attorney's fees in copyright suits. And this is the Kirtsang versus John Wiley case. There was a previous iteration of this case about 2 years ago where the Supreme Court looked at this question of international exhaustion. So that question is whether a sale of a copyrighted work anywhere in the world would exhaust the rights under U.S. law. And so that case was important, or that aspect of the case was important because of this principle of international exhaustion. And this went down again to the lower courts and then now came back up to the Supreme Court on the issue of the standard for attorney's fees in copyright suits. And as some of you may know, that's been a big issue in the area of patent law, and so the court granted cert to look at this issue in the context of copyright. So we didn't talk about this last spring, but we'll talk briefly about it in the context of our discussion today. So the four cases for this term are pretty interesting. They kind of cover a wide range of areas, and one of the interesting sort of general notions that come up in these cases is this protection for design, whether under copyright law or under patent law. So we haven't seen that many design cases that have gone up to the U.S. Supreme Court in a long time, but this term we have two of them, and so those would be very important because that's a growing area of intellectual property work. And so the first of these design cases is Varsity Brands versus Star Athletica. I didn't check the calendar when they've been slated for oral argument, but I can, if there are any questions about that, I can look that up separately. But this is a case that was heavily watched. It has to do with the standard for copyright protection of designs, and specifically the work at issue, as we'll see a little bit later on, are cheerleader uniforms. So the ruling in this case goes beyond that, but it's kind of an interesting area, closely watched, something that affects the fashion industry more broadly, and also affects universities and schools and so forth that might design some of these costumes. The next case is SCA Hygiene Products, Actiobalag versus First Quality Baby Products. And this has to do with latches in patent infringement suits. So there was a case a couple of terms ago regarding latches in the context of copyright infringement suits. And the court basically looked at the statute rather than looking at these common law rules of latches. And the court now is addressing this issue in terms of the statute of limitation under the statute versus any equitable rules like latches in the context of patent infringements. It's an interesting case on its own terms, but also interesting to see whether the court does something different for patent law than it did for copyright law. The third case was really heavily watched, Apple versus Samsung, having to do with the litigation over the design of the iPhone. This got a lot of press for lower court rulings regarding this case. And so the interesting issue that's coming up here before the U.S. Supreme Court is what should the measure of damages be for design patent infringement? Should it be the entire product, or should there be some sort of apportionment for the actual design that was infringed separately from the product? So this, if the court does find it for apportionment, it'll be interesting to see what type of suggestions it might have regarding how to apportion. But the underlying question itself is interesting because the statute seems to suggest no apportionment, even though there's lots of good arguments for why there should be apportionment as a matter of policy and as a matter of equity in these design patent cases. The last case is Life Technologies versus Promega Corporation. And this has to do with patent infringement liability for inducement. It's in a series of cases under 271F of the Patent Act, having to do with situations where a patented item is assembled overseas and then re-imported into the U.S. To what extent can there be patent infringement for making it, even though the making technically occurred outside the U.S. So we'll talk about this, and what makes the Promega case different from predecessor cases is that in this case it has to do with a process, or at least a combination process and product, while the previous cases had to do with products. So we'll talk about all four of these cases very briefly, and then we may have separate, very likely we'll have separate webinars as these cases are argued in the next upcoming months. So let's talk about the first in this series, Halo versus Stryker, which is the standard for enhanced patent damages. This decision came down, I think, last May. We had our webinar in March, and we had a pretty good discussion about how this case should turn out. The issue had to do with Section 284 of the Patent Act, which basically says that upon finding for the claimant, the court shall award the claimant damages adequate to compensate for infringement, and then goes on to say that when the damages are not found by a jury, the court shall assess them, and whether a jury or a judge assesses the damages, the court may increase the damages up to 3 times the amount found or assessed. And so the question is, what is the standard for increasing damages? Is it purely up to the district court discretion, or is there some sort of structured standard or rule that the district court must follow in terms of deciding when a case is appropriate for treble damages? And so the leading case from the Federal Circuit on this matter was In re Seagate, and we'll talk about that in more detail, but the bottom line is In re Seagate has been overruled. In the In re Seagate case, the court had, the Federal Circuit had established a 2-part test that's both objective and subjective, requiring both a objective showing of willfulness as well as a subjective showing of willfulness. And the thing that made this a little bit more interesting than that 2-part test is that the court would never get to the subjective prong if the plaintiff, the patent owner, could not establish that there was no objective basis for willfulness on the part of the infringer. What that means in practice, why these cases got so controversial, is there might be a situation where an alleged infringer basically said at the time that the infringement occurred, we don't care, we'll just take the risk. They may have even subjectively known that the patent existed, but they infringed anyway. But then at the time of litigation, they're able to show that there was some sort of objective basis for challenging the patent, that there's some objective basis for why the patent may have been invalid, and that's meant to undercut any objective basis for willfulness. And so patent owners objected to this 2-part test largely because after the fact, in other words, after infringement, the infringer could come up with any evidence to show, or has a wide latitude in terms of coming up with evidence to show that, look, there was this prior art, or there's this act that could have potentially been a public use or an on sale that would potentially invalidate the patent. And an objective person, reasonable person, could have looked at these facts and assumed that the patent was invalid. And even though at the time of infringement, the infringer really didn't care, it kind of threw caution to the wind and just simply infringed the patent. So this kind of after the fact, almost manufactured defense of invalidity. Of course, if the invalidity defense is valid, we don't even get to damages because there isn't any infringement. But really the question is whether just by bringing in this objective evidence, the court is correct in simply not getting or putting any weight on the subjective prong of the 2-part test. And so the bottom line really boiled down to whether this 2-part test that the Federal Circuit devised is appropriate, and the Supreme Court, as I mentioned, ends up basically overruling Seagate and adopting a different standard, and we'll get to that in a few minutes. And so one of the issues that was raised by the parties in this case is the Supreme Court's ruling in Octane Fitness versus Icon Health, which had to do with exceptional cases. And so in this case, decided 2 years ago, the court again addressed a 2-part test devised by the Federal Circuit in the Brooks Furniture case from 2005. And under that 2-part test, the exceptional cases were ones, again, where there was no objective basis for the party to raise a defense or a claim, and there was a subjective basis on the part of the losing party to get in terms of bringing the claim or bringing some sort of frivolous claim or frivolous defense. So there was a lot of parallels, and these came up in the oral arguments between the 285 situation and the 284 situation. The court in Octane Fitness basically said that exceptional cases should not be based upon this 2-prong test. They basically lowered the standard. But there is an asymmetry between 284 and 285 that we talked about last April. A 285 can apply to both a plaintiff or a defendant. Whoever wins this lawsuit then can pursue attorney's fees. And lowering the standard benefits both the plaintiff, the patent owner, and the defendant in general, because either party could be the winner in any given case. Under 284 has to do with treble damages. That only arises, of course, if the patent owner wins. So lowering the standard for treble damages or enhanced damages would clearly benefit patent owners. And so the argument was raised by the defendants in that case and had a lot of sway, and at least an oral argument, that the standard should be higher for enhanced damages in order to deal with frivolous patent litigation brought by non-practicing entities or patent trolls or whatever the term of the day might be for those types of litigants. And so that argument sort of went back and forth. The bottom line is that the court, in some ways lowered the standard for both attorneys' fees and for treble damages, lowering the burden or the standard for treble damages certainly benefited patent owners. And then the earlier ruling that lowered the standard for the recovery of attorneys' fees really benefits both in the long run in terms of who you'd predict to be benefiting from any particular given rule. Lots of discussion in 285 about how district courts should then decide when a case is exceptional and whether they should target non-practicing entities, especially in terms of situations where they've brought a lawsuit and lost, and therefore then should be penalized through some sort of fee shifting. And so the debate is continuing as to the effects of these different rulings on patent litigation. So let me give you a little bit more context and understanding for what the court did in these cases. Here are the various questions that went in front of the court. Basically, in the Halo case, these are two separate cases that were consolidated. The case the question that the court was looking at is sort of an amalgam of the first two, whether the Federal Circuit erred by applying a rigid two-part test for enhancing patent infringement damages under 35 U.S.C. Section 284. That is the same as the rigid two-part test. In other words, should there be more symmetry between 284 and 285? Was this rigid two-part test wrong? And then the second question is, does a district court have discretion under Section 284 to award enhanced damages where an infringer intentionally copied a direct competitor's patent invention, knew the invention was covered by multiple patents, and made no attempt to avoid infringing the patents on that invention? And in some ways, the second question regarding discretion was more important for the court. The court does rule that there should be a lowered standard, that they reject this two-part test. But one of the reasons, and maybe the principal reason why they do this, is that they wanted to give more discretion to the district court. And that has several implications. One is that the district courts are in a better position to determine whether enhanced damages are appropriate, just like they may be in a better position to determine whether attorney's fees should be awarded to the winning party. And it's also the situation where in some ways the court is getting more skeptical of the Federal Circuit. And so often these decisions by the Supreme Court, especially in patent law, really are reflecting some sort of a tension between the Supreme Court and the Federal Circuit. And by adopting a rule in both cases where more discretion is being given to the district court, not only is the Supreme Court sort of recognizing sort of functionally and structurally the role of the district court in understanding and controlling patent litigation, but also maybe some sort of skepticism about the Federal Circuit intervening and coming up with more structured, bright line rules that are meant to limit district court discretion. There is sort of a shift in the decision-making power in these cases, especially in HALO, from the Federal Circuit to the district court. And so when you look at the holding in the HALO case, there are a couple of things to point out, just to summarize here a little bit, that this was a unanimous decision. Remember, Justice Scalia had passed away in February of this year, so only 8 justices still. And so all eight of them decided to lower the standard. All eight of them agreed that the Federal Circuit's two-part test from Seagate should be overruled, so Seagate is no longer good law. And all eight of them agreed, though there was different emphases on why, but certainly Justice Roberts, writing the opinion, really emphasized the need to grant discretion to the district court in awarding enhanced damages. So lots of really interesting discussion from some of the other justices as to why a lower standard for enhanced damages is appropriate. A lot of it was couched in terms of helping the patent owner, even if some of the patent owners may be bringing frivolous litigation. There's a general sense that having a lower standard, making it easier to get enhanced damages, has some benefit for the patent system and for patent owners. With Justice Roberts and other justices that joined in his opinion, basically emphasizing the important structural role of the district court in awarding enhanced damages. And so this compares with the Octane Fitness case, where again the court rejected a two-part test that was devised by the Federal Circuit, giving the district court more discretion in deciding when attorney fees should be shifted in exceptional cases. Again, these types of the situation under 285 is in some ways is symmetric. It's not one-sided like the enhanced damages cases. So this lower standard could potentially help both patent owners when they win and obviously infringers when they win. And that's kind of an important point to emphasize, because cases after Octane Fitness have been one where there seem to be more leniency in awarding attorneys' fees. And a lot of these cases are ones where the patent owner does tend to win, and the ones in which the infringer wins and gets attorney's fees seem to be ones where the patent owner either did not have a viable claim or there was some question about the validity of the patent and so forth. So it doesn't seem, at least from the 2 years since Octane Fitness was decided, that this new standard is being really used extensively to police, non-practicing entities and patent trolls. And so it'll be interesting to see what happens with this, the willfulness standard for enhanced damages, whether in fact district courts will award enhanced damages more often. And that's something to look out for as to exactly what the standard would be in those types of cases, especially the role of subjective willfulness. It seems like it's no longer the case that a patent infringer can say, well, maybe we were subjectively willful, but a reasonable person would have recognized or thought that the patent was invalid, and therefore that should be enough to not award attorney's fees, not award enhanced damages. And it's possible that that line of attack by unsuccessful infringers is probably shut off now once Seagate is out the door. So let's now talk to Quozo, talk about Quozo versus Lee. This involves the inter partes review proceedings. Some of these things, will be a review, but it's probably worth going into this in some detail because of the importance in inter partes review. And so some of these who saw our presentation back in April, some of these comments may be familiar, but I'll enhance them a little bit in light of the ruling in the court. Basically, the U.S. Patent and Trademark Office wins. So Lee is the commissioner of patents, and so she's representing the interests of the patent office, and they end up winning essentially in this case, both on the standard for interpreting patent claims, as well as on the discretion given to the PTAB on when to bring a IPR action. Okay, so the oral arguments were in April of this year. I think we had the webinar probably a few days or a week beforehand. Excuse me. Two cases in front of the court were the two questions that the court were dealing with. Whether the Court of Appeals erred in holding that in IPR proceedings, the board may construe claims in their broadest reasonable interpretation rather than their plain and ordinary meaning. Court of Appeals here being the Federal Circuit, the Supreme Court here rules in favor of the Federal Circuit. Broadest reasonable interpretation is an appropriate standard. in the context of proceedings that are in the USPTO for understanding what claims mean. And the second question was whether the Court of Appeals erred in holding that even if the board exceeds its statutory authority in instituting an IPR proceeding, the board's decision and whether to institute an IPR proceeding is judicially reviewable. Again, the statute clearly limits judicial review on whether an IPR is granted by the board on that decision. And the court again rules affirming the Federal Circuit, saying that this is not subject to judicial review, under interlocutory review. And the court, kind of goes on this to suggest that there might be other avenues of review based upon administrative procedure, and we'll talk a little bit about that. But basically affirming the Federal Circuit as well as affirming patent office practice as well as what's in the statute. So just to kind of review a little bit about what inter partes reviews are, this allows someone other than the owner of a patent, if you're not the owner of the patent who's bringing this, you need to identify the real parties of interest in the particular case. Either they potential infringers, are they somehow connected to the patent owner, whatever it might be. And it allows this other party to petition the USPTO to invalidate patent claims on the grounds of lack of novelty or non-obviousness based on prior art patents and publications. And these can be brought either 9 months after the grant of a patent or after the termination of any post-grant review of the patent. Okay, so we'll talk about post-grant review separately. Inter partes review is one of these post-grant opposition proceedings that were introduced by the American Invents Act in 2011, went into effect in 2012, with the post-grant review proceedings going into effect a few years afterwards. So even though the particular procedure at issue in this case is inter partes review, as we'll see, there's some parallel statutory provisions for post-grant reviews, and the reasoning in this decision would most likely apply to post-grant reviews as well. So there's a two-step process for review by the Patent and Trademark Appeals Board, or the PTAB. The first is whether to institute the proceeding, and that's before one administrative law judge or ALJ. The standard for the PGR to be instituted is it's more likely than not, or there's some novel or unsettled legal question that's being brought by the challenger. For the IPR, the standard is one of reasonable likelihood that the patent might be invalidated. And under 314D, the decision to institute the proceeding is final and non-appealable, and this is one of the issues that was raised in the Quozo case. Does final and non-appealable actually mean final and non-appealable? And the court said yes, essentially. And then finally, the second step of the process is once the proceeding has been instituted. Is there a question, Jess, or no? The second step is whether there are grounds that exist for invalidation of the patent, and this is determined before a panel of 3 administrative law judges. And here's where the other question comes up. In this particular situation, the panel has to come up with an understanding of what the claims mean. So if they're trying to invalidate the claims, they don't do that in the abstract. They have to have an understanding of what the claims mean. We all know that in the context of litigation, there's a Markman hearing. No Markman hearing within the context of the IPR or this administrative proceeding. So the practice, both for these types of proceedings and then also, of course, for any prosecution, has been to use the broadest reasonable interpretation. So in other words, I kind of view this as sort of a beta test or a control test. Give the widest latitude for what the claims could mean. If they survive a challenge, then that's pretty strong a basis for saying that the claims would be validated, even if you did take a narrower reading, let's say through a Markman hearing process. So broadest reasonable interpretation was the standard. Goes back at least to 1906, decision from a commissioner of patents in the Pottlesack case. You see an affirmation of this standard as recently in 2014. and the Rambus decision, long pedigree, and this was very important for the Supreme Court to basically say, we don't really have any basis to overrule this standard. The Patent Office has been using it, and therefore they do affirm this practice of using the broadest reasonable interpretation. So here it's good to think about litigation in the context of this, and this could be important for how, for some of the implications of Quozo, and certainly did come up in the context of the oral argument for Quozo. And the opinion also talks about some of these implications for litigation. The IPR cannot be instituted if petitioner has brought a declaratory judgment seeking patent invalidation before filing of IPR. This does not apply to counterclaims. It only applies to a declaratory judgment. So there is some strategy here about whether to file a declaratory judgment or to bring an IPR proceeding. If a declaratory judgment action is brought on or after the date of the IPR petition, the civil action is automatically stayed unless the patent owner moves to lift the stay, the patent owner files an infringement suit or counterclaims for infringement, or the petitioner moves to dismiss declaratory judgment actions. So there's a lot of interesting case law developing about the scope of the stay and when these stays can be implemented, and we'll talk a little bit about this in terms of some other aspects of litigation strategy. In the virtual agility case from 2014, the Federal Circuit reversed the district court denial of stay of infringement action when the PTAB review was initiated. So it seems like there's some interesting standards that are developing here regarding district court discretion as to whether to grant the stay or not. Just judging for the virtual agility case, the district court probably is almost required to grant these stays if the statutory requirements are met. But that's, again, something that's developing and may be the subject of future case law. So in the Quozo case, you had Garmin that brought the IPR to challenge Quozo's patent before the PTAB, introducing several pieces of prior art to show the patent was invalid on grounds of lack of novelty and non-obviousness. PTAB finds a reasonable likelihood of success on non-obviousness challenge for some of the claims, but denies the petition on other grounds. The PTAB ends up canceling 3 of the claims on non-obviousness grounds, and the Federal Circuit affirms over Quozo's appeal, both saying, the decision to institute was fine, broadest reasonable interpretation was fine, as well as the finding of non-obviousness was fine. Again, the analysis by the Federal Circuit, and the Supreme Court adopts some of this, is that there's availability of mandamus. There are other types of administrative procedures. There might be an action under the APA when there's a final judgment to challenge the administrative decision. So even though it may be non-reviewable as an interlocutory matter, there are still some avenues of process left open for patent owners who question the institution of the proceeding. As far as broadest reasonable interpretation, it's not in the statute, so there's nothing in the statute that says anything about this approach to claim interpretation. Arguably, there's nothing in the statute that says anything about Markman hearings or anything else either regarding claim construction. So we're dealing with this fuzzy area that may be more in the common law of patents, judge-made law of patents. But the practice of the USPTO has been in the context of examinations, interferences, and re-examination to use this particular standard, and therefore the agency should be given Chevron deference. In other words, if there's some ambiguity in the rule or in the statute that gives the agency authority, then the agency can adopt a reasonable interpretation to fill that gap. And so the view was that's what the agency is doing here. The Federal Circuit did adopt a fairly broad view of Chevron deference. The Supreme Court does adopt a deferential approach to the USPTO on this grounds in this context, but there's an argument that they weren't as deferential as the way in which the Federal Circuit wrote its opinion, and we can compare and contrast that in a minute. Judge Newman, as often the case, wrote a really interesting dissent. It's always good to talk about this. Even though she didn't win the battle, so to speak, or win the war, she put out some really interesting points. that probably will still come up, as these issues regarding IPRs continue. And so her first point is that the post-grad proceeding is a type of adjudication. It's not really agency action. It's different from patent prosecution. And so this question of Chevron deference or deference to agencies in rulemaking may be inappropriate. The broadest reasonable interpretation is examination expedient. It's really about the prosecution process, the public notice function of patents. Remember, these IPRs arise after the patent has been granted, so the patent has been published, the claims, anybody can look at them, the public can see them. And so her point then is that this public notice function is defeated by the BRI, by that standard. There's limited opportunity to amend in the IPR. There's only really one opportunity. And so in terms of dealing with an adverse interpretation of the claims under the BRI standard, the patent owner has very little opportunity to deal with that adverse interpretation. And so here the judge also makes an interesting point that we often think about deference to agency when they're implementing a statute. Here she makes the point that really the agency is changing the statute. They're actually adding language in some ways to the statute, which, as we said, doesn't really address the standard for claim interpretation and construction. And so the deference should not be given when the statute is being changed in such a way. So what's at issue in this case very broadly? I mean, even though the Federal Circuit gets affirmed, it's interesting to see this in terms of the Federal Circuit versus Supreme Court. This can be important for the upcoming cases before the court involving patent law. In the Quozo case, largely it had to do with how Congress construed the statute and drafted the statute. So we weren't talking about special rules created by the Federal Circuit. So the issue of deference or affirming the Federal Circuit is maybe not that surprising. Effectively, the Supreme Court is just affirming Congress, not the Federal Circuit. This really is involving the interpretation of the patent statute. And so largely the bigger question structurally is, what is the place of the USPTO in the scheme of patent law? Should the courts really interfere and review what they do? And the ultimate bottom line in Quozo from that perspective is that the court should really kind of defer more to the USPTO, or at least we get a narrow ruling in the context of inter partes review, where there is this deference to the Patent and Trademark Office, as opposed to the Federal Circuit or the courts more generally. In terms of judicial review type issues, typically the things that come up are common law patent rules, protection of patent owners, protection of patent system. I think in this particular case of Quozo, the Supreme Court is really looking at the third of these, really considering the protection of the patent system to make sure that patents aren't granted to questionable patents. There's a lot of controversy over IPRs. One prominent or ex-member of the Federal Circuit talked about the PTAB in the context of IPR as death panels. I think that's public, and so I don't feel too bad repeating that. And so that gives you some sense of the tenor of the conversation regarding these proceedings. But nonetheless, there is this notion, which I think the Supreme Court affirmed, that there should be some review of patents to make sure that you check the patent office's homework, so to speak, to make sure that the system is not granting invalid or worthless patents. So continuing on this line then, you've got the Supreme Court holding in Quozo. Just to summarize this again, unanimous on the issue of the broadest reasonable interpretation, but there was a split 6-2 on the issue of judicial review, with Justices Alito and Sotomayor, conservative and liberal judges working in harmony here, justices working in harmony here, basically saying that there should be more scope for judicial review of the decision to institute the IPR, and that is something that they really would overrule the statute that limits that type of judicial review. The court upholds the statutory provision limiting judicial review as within Congress's power. So 6 justices agreed with that, especially since there are alternative mechanisms for review, such as mandamus, that still exist. Unanimously, 8-0, the court upholds broadest reasonable interpretation standard as valid exercise of agency power and is grounded in longstanding practice. If Justice Scalia had survived, it would be interesting to see where he would have stood on this. He's not necessarily been a strong fan of administrative agencies in other areas. He's been critical of things like Chevron deference, for example. So it would have been interesting to see what he would have thought about this. The aspect of longstanding practice is something that he might have found as a more convincing argument than the exercise of agency power, but that's kind of a missed opportunity, among other things, in terms of how he would have dealt with the agency in this particular context. And so some of the implications for practice and tech commercialization of the Quozo case. Mandamus is possible under 3 requirements. And so mandamus is a proceeding that allows a review of agency decision-making. There's no other adequate means to obtain relief. The right to issuance of writ is clear and indisputable. It's appropriate under the circumstances. And so the Procter & Gamble case deals in part with this particular standard. And so that's an open question of how mandamus might work in these types of cases if parties, patent owners specifically, start pursuing that avenue to challenge the institution of IPRs and by extension PGRs. There's extra care and burdens in seeking patent protection, so you really want to get it right as the patent applicant and make sure that your patent becomes bulletproof, especially since it is subject to these post-grant proceedings. And the petitioners who bring those proceedings, got a real gift, got a real sort of strong support with the Quozo ruling, both on the standard of reviewing the claims as well as on the judicial review prong of this. One interesting area with these PTAB proceedings is the role of settlement. There is settlement that's possible for IPR proceedings. It has to be approved by the panel, and these IPRs, even though they're brought, I don't have the exact numbers in front of me right now, a lot of them do result in settlements. And so, even though there is a big talk about the death panels, that rhetoric doesn't stand up to the statistics. Because first of all, even though maybe the IPR proceedings are brought, a good proportion of them settle, and the ones that actually go to some final judgment by the board don't necessarily result in the patent being invalidated. So it's kind of an extreme situation. It sort of should be obvious to say that the PTAB and the IPR is where patents go to basically die or be killed. It's a lot more dynamic process. And so these settlements are interesting. We don't have the terms of the settlements, but it's interesting to see what types of cases result in a settlement and whether they're repeat players and so forth. And that's the subject of some ongoing work by practitioners and scholars, including myself. And maybe we'll have some time in a future webinar to discuss settlements in PTAB proceedings as well as other contexts. And finally, we had that little slide about litigation strategy, this whole issue of automatic stays and the role of declaratory judgments. Again, it's something that's going to get worked out in the case law, but it's something worth keeping in mind as you're advising clients and bringing these types of things. So even though we think about tech commercialization largely in terms of licensing issues, and licensing issues may seem far removed from some of the things we've talked about in the context of Quozo, the whole issue of patent validity is an ongoing issue and needs to be thought about even by folks who may be doing more transactional work because you have a patent license. One of the ways in which the patent license might be challenged is by looking at the invalidity of a particular patent. And if you're within the time frame, the IPR and the PGR is one avenue for challenging validity. Okay, so the third case that was decided last term is Kirtsang versus Wiley. This has to do with attorneys' fees in copyright cases. This case didn't get as much of a splash. In some ways, it's a pretty straightforward case, but it's worth talking about. So the brief background is that Kirtsang won the copyright infringement suit brought by Wiley. Kirtsang was a graduate student from Thailand. He was studying, I think, at Cornell and then at UCLA. And what he was doing was buying books cheaply in Thailand and reselling them in the US. I think there's some indication in the records that he made millions of dollars from this practice, but certainly he made enough to cover his cost of living in Ithaca and in Los Angeles, as well as the cost of schooling from this practice, and I think he probably had some money left over. So when this was first challenged by Wiley, Kirtsang won in front of the U.S. Supreme Court, basically the U.S. Supreme Court adopting an international exhaustion principle for copyright law in 2013. So the case gets remanded for other considerations, including the motion for attorney's fees. And so the motion was denied because the district court found Wiley's position objectively reasonable. So again, we get into this question of what the standard should be for attorney's fees. Kirtsen argued, however, that he should have gotten attorney's fees because he had pursued a novel legal theory and was successful. So his view was that one of the reasons why you might grant attorney's fees to the winning side is they took on a lot of risk in terms of pursuing the litigation, and especially if they were successful, and even more so if they were able to be successful against all odds, so to speak, because the Supreme Court adopted some new law, then the award of attorney's fees should be granted. So the district court ruled against Kirtsang on attorney's fees, and then in another unanimous decision, the Supreme Court vacated the denial of attorney's fees with a remand. And so the court ruled that the district court should consider all relevant factors with substantial weight on the reasonableness of the losing party's position. So this is slightly different than what the court said in Octane Fitness. Octane Fitness, that's an attorney's fees case in the patent context. The court talked about looking at the totality of the circumstances and didn't necessarily say that one factor was more important than the other. Here the court is saying that you should look to see objectively whether the losing party did have a reasonable position, and that should be a fairly big factor in deciding whether they should have to pay attorney's fees. The court faulted the district court for ruling that reasonableness created a presumption against fees. So the court rejects this notion that there's any sort of presumption. They do want this sort of totality of the circumstances, it seems. And that's sort of where they're remanding with this little caveat about the reasonableness as being an important factor in this totality analysis. So this is an interesting decision. I mean, it shows the court's interest in attorney's fees. It shows some inconsistency between the patent standard and the copyright standard. But this case, they'll follow this case and let you know what the district court does upon remand with respect to the attorney's fees motion. So those are the three cases last term. I think one certainly very big case, Quozo versus Lee, that has some very important implications for patent practice. The Halo case, very important for litigation and willfulness, especially overruling a 10-year-old precedent from the Federal Circuit that had a lot of people kind of not sure what to do with in terms of the Federal Circuit's two-part test. And so there's a brave new world for enhanced damages. And then, in terms of this attorney's fees issues, there's still some things that are being, worked out both in the patent area and in the copyright area. So now we've got a whole, set of cases that are before the court this term, and I just want to go through these very quickly. We've got about 10, 15 minutes left, so I'm not going to go. I'll talk briefly about what the lower courts did and the issues that the court is reviewing in these cases, and also give you a sense of the, what's at stake. This one's a pretty interesting case. It has to do with copyright protection for designs. These are the designs at issue. The copyright in these cheerleader outfits is owned by Varsity Brands, and it's a copyright infringement lawsuit brought against Star Athletica. And we're not getting to the infringement analysis here. We're just simply getting here about the copyright ownership. And so Star Athletica had been challenging, whether there's anything original or creative here under copyright law that deserves copyright protection. These copyrights are registered. As you know, the copyrights have to be registered before you bring a lawsuit to enforce infringement. So these were registered, and one of the issues that was raised is, what deference or what role does the registration have? We know that under the statute, the registration can create some sort of, is enough to make a prima facie case of ownership. And so the Star Athletica was sort of challenging, what relevance the registration has as far as originality or creativity. The Supreme Court didn't review that question. The Star Athletica they did ask to review that particular question, Varsity Brands, but the Supreme Court didn't grant review in that particular question. Instead, they decided to review the question of the underlying copyrightability of the designs here. Varsity Brands losing in the lower court level and then bringing this lawsuit. The question that's in front of the court is, what is the appropriate test to determine when a feature of a useful article is protectable under Section 101 of the Copyright Act? And it didn't grant cert on the issue of copyright registration, as I just mentioned. And so this question, the useful article doctrine, exists under Section 101. It applies to works that are pictorial or graphical or sculptural in nature. And so people may be familiar with these cases. There's a really interesting line of cases. They involve all sorts of works, dressmaker dummies, mannequin heads that are used in cosmetology school, lamps, clocks, you name it. There are all these sorts of works that have both functional features as well as aesthetic features. And copyright law is meant to only protect the aesthetic features, not the functional features. Functional features, if at all, can be protected by patents. So this is kind of a real, seminal question, foundational question about the line between copyright and patents, as well as the specific question about when you determine when something is copyrightable. And this stuff has been litigated since at least the 50s. There's lots of cases beforehand, but they came up to the fore, as design became more of an industry and a field. You see a lot of these cases coming up, since the 1950s. The 1976 Copyright Act has expressed statutory language that deals with this particular issue, and there's lots of litigation under that statute. The Sixth Circuit that ruled against Varsity Brands here, so this is the Intermediate Appellate Court, basically identified 9 tests that courts have come up with to determine copyrightability for useful articles. And I won't go through all 9 of those tests, but largely they have to do with some sort of separability. So for example, if you can physically separate the sculptural or the aesthetic aspects of a work from the functional aspects. So, take the example of a clock. If you can somehow take out all the functional aspects, all the clockwork, and you're left with something that looks like a sculpture or a statue, then you've got something that can be copyrightable. It gets a lot more complicated when you're dealing with designs, to go back a little bit, like here. I mean, what do you separate in terms of figuring out what's functional? So clearly these armholes here, have a functional dimension, but they're also aesthetic. I mean, they sort of have some kind of pleasing feature or whatever it might be. Same thing with collars. I mean, how do you separate all the elements of things that are functional for clothing from things that look good? They somehow seem inextricably mixed or intertwined. And if they are inextricably intertwined, the copyright owner loses. Because if you can't separate them, then the court is very hesitant to grant copyright protection to things that really should be not copyrighted. And so that's why lots of litigation on these issues, and this is why it's especially interesting for the fashion industry. because they're heavily invested in protecting the aesthetic features, even though there are lots of folks who say, well, fashion is just it just basically the dress has to stay up, or it has to fit the body in a particular way, or it has to keep you warm. So it really is not, it's really functional rather than purely aesthetic. So the Sixth Circuit adopted a test that required the court to identify utilitarian features first and then ask whether these can exist separately from aesthetic features when looked at from the perspective of an objective viewer. And so that's one of the 9 tests, or maybe a hybrid of some of these 9 tests. And so what the Supreme Court is going to be doing is really look at what the lower courts have been doing for the last 40, 50 years and try to figure out an answer to this question. I don't feel all that optimistic that they're going to come up with an answer. I don't know if there is one right test. So most likely what the Supreme Court is going to do, it would be interesting to see what their analysis and discussion here is, but most likely what they're going to do is just lay out, distill from these 9 tests some fairly abstract and general principles and basically tell the district courts, run with these to see how they would apply in practice. But it'll be interesting to say, maybe there is one test out there that really resolves questions about how to decide the copyrightability of a dress. But I'm skeptical about that. But nonetheless, this case has a lot of people excited. Academics are excited, practitioners are excited, people in the fashion industry are excited, because the court really hasn't dealt with a good design case in a long time. And as you can see, with 9 tests that the lower courts have come up with, there's been a lot of controversy, at the lower court level. So SCA hygiene is about latches, so this is really purely in the litigation context. Latches is sort of an equitable statute of limitations. Has the patent owner sat on her rights too long to bring the suit? So this is typically asking that even if you're within the statute of limitations period, you still should be barred or time barred from bringing the suit because you didn't bring the suit in a timely fashion. And so the highlights of this case, main question under review is whether and to what extent the defense of latches applies within the 6-year statute of limitations for patent infringement claims. This, as I mentioned before, is a follow-up to the Supreme Court decision in Petrella versus Metro-Goldwyn-Mayer, really interesting case involving the movie Raging Bull. And Petrella is I think, granddaughter, I forget exactly what her relationship is, of Jake LaMotta, and lots of questions about the copyright in the underlying material that became the movie Raging Bull. And so Raging Bull came out in 1980, so this kind of latches issues is pretty interesting in terms of how long a copyright owner can sit on her rights. But the court in that case basically held that latches does not apply within the 3-year statute of limitations for copyright infringement claims. So you basically follow the statute. This is another one of these opinions that basically says follow what Congress says rather than trying to create some sort of judge-made rule about equitable statute of limitations. And this is another case where the court gets to review the Federal Circuit, because in the Ackerman case from 1992, the Federal Circuit has ruled to allow latches. So on the one hand, you've got this asymmetry, no latches under copyright law under Petrella. Federal Circuit says there are latches under patent law. No reason why patent law and copyright law should be exactly the same, but it raises some interesting practice questions if they are different, especially since an attorney might have a client who has both patent issues and copyright issues. You need to kind of keep those straight if there are different legal standards that apply there. So very interesting to see what will happen in this case on a number of levels, copyright versus patent, and then again, Supreme Court versus Federal Circuit. Apple versus Samsung, really fun case, the battle between smartphones, and this has to do with the damages for design patent. The question under review is whether a design patent applies to only a component of a product. Should a district court be required to limit its award of infringers' profits to those profits attributable to the components? So basically we're asking for apportionment. If you have, let's say, in this case, it's a design patent over the shape of an iPhone, Do you get the full do you get the full $600? Let's say that's what we say the price of that iPhone is. Somebody buys the Samsung product rather than the iPhone, so Apple is out $600. Should Apple be able to recover the full $600 or only the portion that's somehow attributable to the design? So if the court says there should be some attribution or apportionment, then there are these hidden issues about how you're going to apportion, right? So what portion of the value of an iPhone is to its design, what portion is to its functional components, and so forth. So, if the court does rule in favor of apportionment, that's going to open up some very interesting litigation in the future. The Federal Circuit held against separability and against apportionment, basically following the statute, which basically says you get the full value of the product in the design patent statute. And so this is an interesting case not only because of the smartphone wars, but also because of another case involving design protection. So you got two cases where the Supreme Court is addressing this question of design protection, after several decades. So for those who are in that area of the law, and that's an increasingly growing area of the law, it's pretty exciting developments. Okay, so the last cases that the court has decided so far is Life Technologies versus Promega, and this has to do with liability under 271F1 of the patent statute. And the question that the court is reviewing is, does supplying a single component of a multi-component invention from the United States constitute patent infringement, exposing the manufacturer liability for worldwide sales? So the product is under patent in the U.S., somebody exports some components of the product overseas, and the product is actually put together overseas where it's not infringing, and then it's going to be sold worldwide. What should be the nature of liability for the people who provided the components? And here specifically, you're dealing with processes, so this makes a little nuance to this case. The Federal Circuit says it does. The statute does impose liability, even if you're just applying a single component. And so the Supreme Court will review both the statute. Another interesting case where the court has to kind of look at the statute, look at the Federal Circuit interpretation, and make some decision. And so, this case is interesting, not just simply for the specific technical issue of components and patent infringement, but also this question about U.S. law applying, outside its borders. And so we'll have some opportunity probably later on this year to talk about this case. So just to quickly sum up some implications for practice overall, based upon these four cases, what to look out for. Court is focused on specific practical aspects of intellectual. These are pretty nitty-gritty cases. They're technical cases about the statute. They're about statute of limitations. They're about damages, about copyrightability. So really very, very practical type cases. The court is concerned with judicial administration of intellectual property, especially the role of district courts and the relationship to the Federal Circuit. And the last point that a number of people have made is that there are only 8 justices on the court. I don't know whether we're going to get a 9th and when we'll get a 9th, or even who that 9th person might be. And so one of the reasons why some people are speculating that the court has taken so many IP cases is, well, I guess they want to have fun too, but they're less willing to take controversial cases. So especially if they're going to be divided in this way with potential 4-4 votes. Intellectual property cases is one area where they've gotten fairly good unanimity across lines, and so that may be one reason why we've seen these spate of cases, and I think people expect to see more actually this term. Couple of cases involving First Amendment and trademark law and so forth that the court might grant. And so as far as technology transfer, the things to look out for, what is protected as intellectual property? Is something copyrightable, right? What is protected by design? These are kind of very important questions to keep in mind when you're drafting licenses and when you're trying to negotiate transfers of intellectual property. You need to be aware of administrative procedures such as the IPR and registration. litigation threats, to what extent is that being mitigated by changing the standard for attorney's fees or changing the standard for enhanced damages. And it's interesting to think about the general attitudes towards commercialization and technology. One of the reasons why the court might be granting these cases is that it is a court, both on liberal and conservative lines, that is concerned about how the law is affecting business. And so it's not surprising from that perspective that they are taking a lot of these IP cases over the last several years because of its importance for commercialization technology and the kind of things that many of us and many lawyers are practicing today. So thanks for your patience. I hope this was informative. I look forward to taking any questions you might have either now or afterwards.